What is sexual harassment? Now, the common definition of sexual harassment may be obvious to most people, but under California's Fair Employment and Housing Act, it's not as obvious as you would think. Now, the definition of sexual harassment is defined as severe and/or pervasive conduct. And it also depends on who's doing the sexual harassment. If it's your coworker, your employer is not liable for the sexual harassment unless you put them on notice of it. On the other hand, if it's a supervisor who's creating the hostile work environment, your employee is strictly liable for any of your damages. Now, what's important if you're being sexually harassed in the workplace is to create a detailed written record of all the conduct. Let your employer know about it. Put them on notice. Now, this is really important. If you're being retaliated against for reporting sexual harassment, you must document everything. Put it in writing. Let your employer know that you're being retaliated against. Common form of retaliation in California when an employee reports sexual harassment is wrongful termination. That's illegal. If you've been wrongfully terminated in California, you're entitled to various forms of damages. The first form of damages you're entitled to is compensatory damages. That means you can get lost wages, past and future, and you can be compensated for your emotional distress, your pain and suffering. If you've been sexually harassed in the workplace, you could be entitled to emotional distress damages for the conduct. The third form of damages is your attorney's fees. If you bring an attorney to help you with your employment law claim, your employer can be liable for those damages as well. The fourth and final form of damages is punitive damages. Those are designed to punish the employer for the sexual harassment. It's very important to contact an employment law attorney as soon as you can because there's something called statute of limitations. Luckily in California, the California Fair Employment and Housing Act gives you 3 years to file a right to sue. Once you file a right to sue, you're given another year to file in court. But these laws can change. Every case is different. Your case has nuances. Now, if you've been sexually harassed in California, it's extremely important that you contact an attorney as soon as possible. Why? Because there's something called a statute of limitations. That means you have a deadline to file a lawsuit in California. If you don't file within the deadline, you're forever barred from getting damages. Now, luckily in California, the statute of limitations for an employment law claim regarding sexual harassment is 3 years. And you have 3 years to file a right to sue with the Department of Fair Employment and Housing. Contact one of the employment attorneys at Miracle Mile Law Group who are specifically trained in sexual harassment cases. We'll provide a free consultation. We'll make sure you get the help you need. We're advocates.